Prime Minister Dean Barrow has announced that the government of Belize will not be appealing the decision of the Chief Justice, Kenneth Benjamin, as it relates to the Section 53 of the Constitution that was amended. Chief Justice Benjamin rendered his decision on Wednesday, August 10, declaring Section 53 unconstitutional, as it finds it criminal for consenting adults to engage in sodomy or anal intercourse. The Public Court of Opinions has seen many opposing the ruling, while others embracing it. To get a sense of the ruling, Attorney General Vanessa Retreat opened the press conference hosted this afternoon by the government of Belize at the Belize Biltmore Plaza.
It is the government's duty to regard the decision primarily as a matter of the interpretation and application of the Constitution, and to fully accept that the court is the guardian of the Constitution and is entrusted by the very Constitution to perform that role. The decision to amend Section 53 of the Criminal Code to decriminalize consensual sexual acts between adults in private has generated much controversy. However, the government must accept, as the court has stated, that public opinion cannot be allowed to shift the court from performing its solemn duty to interpret the Constitution or the government from its duty to respect the decision of the court. In this regard, it is of utmost importance that the public understands the findings of the Honorable Chief Justice in their barest form without the bias of either opposing view. The government, in considering whether it would appeal, embarked on this sober exercise for itself and found the following to be the findings of the Honorable Chief Justice. 1, that consensual sexual acts between adults in private is no longer a crime. And 2, that the Constitution, as it now reads without any amendment, should be interpreted so as to prevent discrimination against any person as a result of that person's sexual orientation. Those are the very narrow and limited findings of the Chief Justice. The government has closely considered the option of appealing and has sought legal advice as to the possible merits and benefits of appealing. In this regard, it is noted that there were 7 interested organizations which argued the case apart from the claimant and the government, with no less than 15 attorneys representing them. Government is therefore satisfied that the case was properly argued and does not see any aspect of the decision that would benefit from further argument, and as such has taken the decision not to appeal.
With the announcement that the government will not seek to appeal, Prime Minister explained how they came about with this decision.
The position we have taken was come to after a very spirited debate was had among members of Cabinet. The Cabinet is no different from the wider society, and this issue has attracted different opinions that are fiercely held. Cabinet, therefore, wants it to be made absolutely clear that the position taken is driven principally by what the Honorable Attorney General has said, a considered examination of the legal merits or otherwise of an appeal. In other words, there are very many members of Cabinet who would want to make clear that their support of the decision taken must be placed in that narrow legal context. It should not be interpreted as any blanket support for LGBT positions. Similarly, there are members of cabinet who do support those positions. And that is why it is so important to make clear that where cabinet comes together and is prepared to act as one in a united fashion is on this question of the legal merits of the decision given by the Honorable Chief Justice.
As it relates to an appeal of the judgment, Attorney General Retriege indicated that the churches do have a way for an appeal.
Also conscious that the option of appealing is open to one or more of the interested parties, and it is not the government's intent to influence or in any way preclude any legal steps which others may consider that they wish to pursue. The government is, however, satisfied that it must not appeal simply for the sake of appealing, but must ensure that its actions best serves the interests of the Belizean people. The court has decided that Section 53, which was challenged, was a law which criminalized private sexual conduct between consenting adults and therefore discriminated against the right to privacy and dignity. The government respects that decision and finding.
Today's press conference saw the presence of several private citizens in attendance, as well as members of the religious community.